that I need to record as well. Right. Okay. Good evening for those of us dialing in from Eastern Australia, and good morning and good afternoon for those joining today's installment of the CERN Discussion Series from the Philippines, Indonesia, Malaysia, Singapore, the US, and the UK, to name a few. Because many of us on this call are currently in Australia, I would like to begin with the Australian custom of acknowledgement of country. Waminjeka, my name is Alex de la Cruz, a PhD candidate at Melbourne Law School, and I acknowledge that I am an uninvited Filipino guest living and working on stolen land belonging to the Wurundjeri people of the Kulin Nation, whose sovereignty was never ceded. I acknowledge Wurundjeri laws and pay my respects to their elders, past, present, and emerging. A few points for housekeeping. Our speaker will present on his topic for 40 minutes, which will be followed by 20 minutes of questions from the audience. Please keep your microphones muted for the duration of the presentation, after which I will open the floor for questions. You may ask a question, which ideally should be brief, by using the raise hand function in the reactions button below, or by leaving a question in the chat box to the right. This will be a recorded session. A bit about CERN. So CERN stands for the Cities and Environments Research Network. It is a collective of Filipino postgraduate scholars, PhDs, postdocs, and lecturers based at Australian universities with research interests in the Philippines at the junctures of planning, development, disaster, education, design, art, communication, and ecology. We started the discussion series in the early days of the COVID-19 pandemic last year, covering a diverse range of topics focusing on the Philippines, such as disaster communication, the right to the city, indigeneity, women's issues, public health, and sustainable procurement. Recordings of past discussions are now searchable on YouTube using the keyword CERN Melbourne. Now on to our speaker, to whom I extend solidarity over the extended lockdown in the state of New South Wales. Dr. Lowell Bautista is Senior Lecturer and Head of Postgraduate Studies at the School of Law and the Australian National Centre for Ocean Resources and Security, or ANCRS, in the Faculty of Business and Law at the University of Wollongong, New South Wales, Australia. Dr. Bautista is recognized for his expertise in the law of the sea, particularly for his contributions in the area of territorial and maritime disputes in the Asia-Pacific, especially on the South China Sea. He holds the degrees of Bachelor of Arts in Political Science, cum laude, and Bachelor of Laws from the University of the Philippines, a Master of Laws degree from Dalhousie University in Canada, and a Doctor of Philosophy in Law from the University of Wollongong. Thank you, Dr. Bautista, for accepting our invitation to present with CERN this evening. Handing over to you.
Okay, magandang gabi, magandang hapon, and good evening. It's currently 6 p.m. here in Sydney, Australia, and I'm grateful and very much privileged, and it's my honor and pleasure to present this important topic with you today. Thank you, Alex, for the generous introduction, which is typical of Filipino styled presentations. And I see a lot of familiar faces, names in the participants list. So I hope you learned something from tonight's presentation, and maraming salamat for your time. So I'm speaking on the topic, the South China Sea Arbitral Award and Enforcement of Judgments in International Law. So please allow me to preface my presentation with this quote, and it says, "You're never in the wrong place. Sometimes you are in the right place, looking at things in the wrong way. Okay, please allow me to repeat that. You are never in the wrong place. Sometimes you are in the right place, but you're looking at things in a wrong way. Actually, I don't know who said this quote, but I was reflecting on this presentation, and recently there have been a lot of discussion in the social media, in the national broadsheets of the Philippines, and elsewhere about the Arbitral Award, and also about the recent events in the South China Sea. And it's very opportune because we celebrated 5 years of the Arbitral Award just a few weeks ago. So I think this is a very appropriate perspective. And it's always when I look at things, when I present, whenever I analyze situations, I think framing and perspective is always very, very crucial. So hopefully you can grasp from this opening slide where I'm headed. I'm also reminded of what Marcus already said in another book, which says everything we see is perspective, not the truth. And really, it is true. You know, life is a matter of perspective. I think it's very sound advice. It's something which is full of wisdom. It's, and personally and professionally, it took me an entire lifetime to learn and apply this lesson. And when we think of the South China Sea, and I'm speaking very in broad sweeps, and I'm sure some of you are training the law, some of you may not be. Some of you are aware of what's happening. Some of you might have a passing interest in the area of the South China Sea disputes. We often think of it in a very negative way. So we think of it as it has a very destabilizing role in Southeast Asia. There are debates on how complicated the issue is because there's a lot of claimant states. The features in themselves are not really important, but they're very important strategic value for the claimant states. We also can think of the South China Sea as an area where freedom of navigation is important because it's important for regional and global trade. There's a lot of fishery resources in the South China Sea and also expected to have oil and gas. So all of these things, it's really layers upon layers of possible analysis and perspectives. And I read somewhere, I mean, I don't know if I'm quoting correctly, but one author said, what is wrong with perspective is that it is incomplete. So it's not always the case that it is wrong, but when you look at things from perspective, as we often do, because of our professional, personal, or even our national interest, it is not so much that it is wrong, but it's often incomplete. So when we look at the South China Sea, we might have a very destabilizing negative idea of the disputes, and then we further compartmentalize it into different aspects or layers. And then what we have are actually incomplete analysis or perspectives, which are, as I said, not essentially incorrect, but they're actually incomplete. So, and of course, how can I be remiss of my national and patriotic duty to remind us of this glorious victory that we waited for nearly a century. So Heidelin Diaz winning the gold medal, the first ever for the Philippines in the Olympics in Tokyo just recently. So I think these two pictures that you see on the screen quite vividly captures, two very opposing views. The first one is, the Philippine flag being hoisted there and the national anthem being sung. And then you might be wondering why this scrap of paper in a wastebasket doing on the other side, because you might recall, of course, the Chinese saying that the award is a mere scrap of paper. But tonight I want you to open your mind, and I'm posing this question to you provocatively. Did the Philippines really win in the South China Sea Arbitral Award? What have we won? What is the content of the victory? So I say this in brutal honesty, because if you look at the toxic exchanges in social media recently, and there's been quite a resurgence, people have been quite derisive of the award. They're saying we haven't really won anything. We haven't settled the South China Sea dispute or West Philippine Sea dispute. It is actually irrelevant. Some people in the highest positions of government think of it as a mere scrap of paper. It's not implementable. It is something which cannot be enforced. So ask yourself tonight, have we really won anything? Have we won? What did we win? Is it really a win that we have in the South Chinese Arbitral, or is it a mere scrap of paper? And of course, if you ask me, since you're listening to me, of course, the answer to the first question is yes. So, do the Philippines really win in the South Chinese Arbitral Award? Of course, and you will see this very, very shortly in the next couple of slides. The answer is clearly a categorical yes. We won in the South China Sea Arbitral Award. But the other important question is, how we implemented the award, and this is where it becomes a bit wobbly. And the answer is more nuanced. And for those who are uninitiated in international law, and I say this with pardon the slight arrogance, it may appear so that we have not, but in reality, and in many ways, both obvious and subtle, this might surprise you, the award has actually been implemented. So when you look at the social media exchanges, people who purport to be scholars and experts in international relations or politics or even international law claim otherwise, but I submit to you that not only that we have won in the South China Sea Arbitral Award, but in fact it's also been implemented in ways which are subtle and of course obvious, and in ways which are beneficial for the government and the party's position, and also for our territorial claims in the long term. Okay, so just like the victory I'm very mindful now because it's recorded, but anyway, I'll say it in a general way. Just like the victory of Heidi Indias in the Olympics, my confidence does not lie in the capacity of the Philippine government to enforce the arbitral award. And I say this with all due respect, of course. I mean, we don't have the military, the economic capacity or power to enforce the award, but in the power and force of international law. And that alone carries its own force and power. So, in other words, I trust the process. I trust the process. And just like pictures, ideas are powerful. Ideas which challenge other ideas have force in themselves. And as they say, there's no stronger force in the world than an idea whose time has come. And so if you recall, before 2012, before 2016, and I know this for a fact in personally, when you attend conferences, when you read scholarship, when you have for those of you in government, when you sit in negotiating tables, you will hear the mantra that China has indisputable sovereignty over the South China Sea, and they point to you the 9-dash line, and that alone will tell you how in stark contrast where we are now, because right where we are now is where the point where you no longer have to be respectful to China when it does that, because it has been categorically dismantled or denied in the arbitral award, that there's no such thing as a 9-dash line. Then China's historic claims in the South China Sea based on that legal fiction should not be countenanced, and it's actually should not be honored. So I think I'm getting ahead of myself. But anyway, that's my general points. If you take anything out of this discussion, I think you should remind yourself that 5 years after the award, there should be no point where you are in doubt of whether or not what we have won in the award. The extent and gravity of the award, the magnitude of the award is so overwhelming and breathtaking, and in fact monumental in international law. And it just pains me, and it's so disheartening when you see and observe from overseas Filipinos who are trying to disparage the award and rob the Filipinos of the joy and the victory of that litigation. Because I'm a scholar and a teacher, I like to quote important people. So I have on your screen a quote from Louis Henkin, who is widely considered one of the most influential contemporary scholars of international law. In 1979, he said in his book, How Nations Behave, that almost all nations observe almost all principles of international law and almost all of their obligations almost all of the time. I like this phrase just because it has so many almost in there. So it's almost a tongue twister in itself. So almost all nations observe almost all principles of international law, almost all of the obligations, almost all of the time. It's quite a mouthful to say, but I think it's very insightful. It's actually it touches to the very heart of the issue of compliance under international law. In other words, why do nations obey international law? And it might surprise you, but the general inclination of states in the international community of nations is actually one of compliance. And in spite of its structural weaknesses, the inadequacy of the sanctions, the mediocrity of the norms, the international normative order is actually very orderly and stable. So if you look at the PC, the Permanent Court of Arbitration, there are over 100 interstate disputes there. If you look at the WTO system, hundreds of disputes as well. If you look at the docket of the ICJ, the UNCLOS cases, people look at the international system and fault the system for something which it is not, because when you are well versed and familiar with the domestic system, when there's a sheriff who enforces judgments, and then you transpose that expectation to the international system, which is really very anarchic in nature. It's phenomenal. There's really no overarching, no singular, no monolithic, power or force or unit or institution that enforces the award. You might think that it's a failure of the system, whereas actually the truth is it's a failure of your understanding of the system. And the system works. The system works because we know that all of these tribunals, their adjudicators are people who are white and old and just normal human beings, just like us. But their awards are actually enforced, they're obeyed, they're respected. And we see this across areas of international law, human rights, trade, the law of the sea, investment. So it's almost safe to say that compliance is actually the norm. And we see that all the time. So the pattern of state behavior can be accurately described as one of conformity and compliance. And it is the same proposition that we see in international courts, in their judgments, and they are all complied with without need of enforcement. Of course, there are a few wayward cases, and of course, some scholars will point to you, or pundits will point to you to the Nicaraguan or the Chagos one. But over time, I mean, you can look at it from a very longitudinal perspective, and you can see that it's also one of compliance. And in fact, there's a general duty to comply in international law. All states have the duty to fulfill their commitments in good faith. There is a principle called pacta sunt servanda, which is a rule of customary international law codified in the Vienna Convention on the Law of Treaties. States also have the duty to cooperate with one another. There's also the general prohibition for the threat of or use of force under the UN Charter, so that the actions of state do not endanger peace. There's security and justice. Okay, so really the issue of enforcement is very vexing or perplexing, and in fact, it is actually more pronounced, as I said, if you compare the domestic system with the international system. But even again, another quote, my apologies, Harold Koch in 1997 said, Harold Koch, for those who don't know about him, is actually the former dean of the law school, and he's also a former legal advisor to the U.S. Department of State. He said, like most laws, international rules are rarely enforced, but they usually obeyed. So again, it's a reinforcement of the earlier propositions that I told you, that compliance and enforcement, which go hand in hand, they're actually a norm under international law. And we don't follow the system for things which are systemic in nature. That's how international law operates. So tonight, hopefully, things will become clear in your head, and you will be fully convinced that the arbitral award is a victory, and in fact, it has been implemented. Okay, so with those preliminary points in mind, in the next half hour or so, I wish to address the following three questions or points. So the first one is, how did we get here? So the first part of the presentation will cover a very brief overview of the South China Sea disputes. Who are the claimants, why is it important? We'll have a quick look at the relevant provisions of the Law of the Sea Convention, particularly Part 15, which sets out the dispute settlement regime under the convention. Part 2 of the presentation asks the question, where are we now? So we find ourselves with the arbitral award. So we will look closely at the arbitration filed with the Philippines against China. Specifically in this part, we will look at two things. The first part is the arbitration case filed by the Philippines, including the questions that the Philippines wants the tribunal to address, and the reliefs that the Philippines sought from the tribunal. And we look at some critical aspects of the award. I invite you personally to read the 500-page award on the merits of June 12, 2016, because it's really a good read, especially if you're a student of international law, and even if you're just a patriot, because you'll find that there are things there which are particularly relevant, and it will give you a sense of pride and also an understanding of again, the victory that we won in that award. And finally, in the last part, where are we going? So how did we get here? Where are we now? Where are we going? And in the last part, we will look at what has happened since the award in a very condensed way. We will look at the relevance and limitations of international law, some practical ways to enforce the award, implications, options, and recommendations. So those are my tasks for tonight. So before I became a full-time academic, I was actually a practicing lawyer in the Philippines. And one thing I recall when a client comes to me for advice when I was still practicing is to, they usually ask the question, what are the chances of the case succeeding? And in my years of practice in law, one thing that I learned is that it's always best to be honest. And so please allow me to start with some bad news first. So the Philippine arbitration against China will not resolve the dispute over the West Philippine Sea. So the arbitration will not settle the issue of ownership or sovereignty over the disputed features of the South China Sea. The arbitration will also not settle the delimitation issue. So there are two issues when we talk about the South China Sea or West Philippine Sea. The first one is territorial, so who owns the islands or the insular features in the South China Sea, which is governed by principles of customary international law. And the second one is maritime. So the maritime zones generated by the features, overlaps, and also the sovereign rights that pertain to them, who has the sovereignty or sovereign jurisdiction or sovereign rights over those resources. So unfortunately, the arbitration does not settle the issue of ownership or sovereignty. So that has to be settled at a later date because that's not part of the arbitration. And in fact, the law of the sea does not contain any rules that will resolve the dispute over the West Philippine Sea. So it's often a misunderstanding that people look at the Law of the Sea Convention for a pronouncement or rules that govern title of the territory, which of course you cannot find there because the Law of the Sea works on the premise of established land boundaries and does not contain rules that determine who owns the disputed islands. So contrary to the popular belief, we find this not in the convention itself, but in the general corpus of cases decided by the international judicial bodies and in customary international law, particularly in respect of the acquisition territory and there are established modes to do this. So the Philippines this is a bit controversial and you may wish to disagree with me. So the Philippines has lost physical occupation of Scarborough Shoal. And I emphasize they're lost physical and not any other occupation with legal ramifications. So before 2012, as you know, before the Scarborough Shoal incident, neither China or the Philippines had permanent military presence in the Scarborough Shoal or Bajo de Mosunloc. Fishermen from the Philippines, China, and other countries are able to fish in that area. In fact, fishermen from Vietnam, Taiwan, and China, the Philippines operated around the reef. But after the standoff, and I have good reason to believe from my information, secondhand information from reliable sources, that it's still the case in the Scarborough Shoal at the moment, that our fishermen are prevented from fishing in the area. And that the other point I want to make there is that the reclamation activities that were done by China in the features that they occupied have done reparable damage to the marine environment of the South China Sea. And these are all well documented. So China occupies 8 features in the South China Sea, plus Scarborough Shoal, if you want to include that in the list. And among the features that they occupy, a lot of them, they've built massive structures, artificial structures, and in doing so, they've actually done irreparable damage to the marine environment. So those are the bad news. And of course, this is the last one. China does not honor the ruling. So they have made it quite clear from the get-go, consistently during and even after, that they will not honor the ruling. They do not respect the tribunal. They think it's an abusive process. They have no intention of implementing the award or enforcing the award. So those are the bad news. Now we look at some of the videos. So the final award of the arbitral tribunal is an overwhelming legal and moral victory for the Philippines. So the Philippines won a massive legal victory, and of course a moral victory, if I may say so as well. And part of that victory is the declaration that China's non-dash line claim finds no basis in international law. And again, that's quite a mouthful to say, but this, for our purposes, just means that the tribunal has declared that the historic rights of China in the South China Sea on the basis of the 9-dash line is not compatible with the UN Convention on the Law of the Sea. It also finds no basis in international law. It said in the award, if you read the award, that the China does not possess historic rights over the resources of within the 9-dash line or any of the areas within the Philippine Sea or continental shelf, and that any historic rights which China may have had over these resources are incompatible and are therefore extinguished when China acceded to the UNCLOS and upon its entry into force. So the tribunal was actually very mindful of its sovereignty and of its jurisdiction rather, and it carefully avoided the issue of sovereignty. And we will look at this point in other slides. And it clarified that the historic rights of China claims over the living and non-living resources within the 9-dash line are beyond the limits of what is provided for under UNCLOS, and in fact they have been superseded upon its entry into force. In other words, the tribunal is saying this China is a state party to the UN Convention on the Law of the Sea. That is the law which applies to the relationship of China with the Philippines. And because of the respective rights within the convention, its historic rights are deemed extinguished or superseded, and therefore it is incompatible and has no basis in international law. So that's just an expansion. In other words, China's 9-dash line is categorically declared as without basis. And it's a good juxtaposition with China's position. The arbitral tribunal award is final, it's binding, it's enforceable, and it carries presidential weight. So the right of the Philippines to institute the arbitration is incontestable. Both the Philippines and China are parties to the UN Convention on the Law of the Sea. They have ratified and they've signed to the compulsory dispute settlement mechanism, which is in part 15 of the convention. China did not participate in the arbitration at any stage. However, the procedure of the UNCLOS ensures that the refusal of China to participate in the proceedings did not impair or frustrate the proceedings or the validity of the arbitral award. So you find this in Article 9, Annex 7 of the convention. China, on its part, has no duty to appear before the tribunal. However, it has a duty to comply with the decision of the tribunal, and its non-appearance did not affect the validity of the judgment. It is final, and there's no provision for appeal as provided for in relevant provisions of the convention. So I think this is worth emphasizing, because if you look at the again, I'm quite distressed and discouraged, disheartened with recent literature and exchanges in social media which attack the strategy and try to insinuate otherwise. So the Philippines, the right of the Philippines to institute the proceedings is incontrovertible, as well as the award that it received, which is final, it is binding, there's no provision for appeal, it's enforceable, and it doesn't matter that China didn't participate. So I mean, I don't want the China or Chinese officials state or clearly state their positions, but I'm more troubled when Filipinos and Filipino officials seem to mimic or echo or articulate the same positions, because it's, of course, it's all falsities. Okay, images, as I said, just like words, are quite powerful. So this is this statement from our former secretary is really something that I recall and vividly remember. And he said in 2012 that the whole world knows that China has a myriad more ships and aircraft in the Philippines. At this end, however, we hope to demonstrate that international law would be the great equalizer. So The imagery, of course, is slightly related to the quote. But one point I also want to emphasize tonight is that there's really no Davis or Goliath in international law. We need to remove this idea from our heads. It's a cardinal principle of international law that forms a backbone on the law of maritime boundary limitation and territorial acquisition, that all states are born equal. So in the United Nations, this is a cardinal principle. So there's a principle of the sovereign equality of all of its member states, and in fact, the sovereign equality of all competing coastal states. So if you find this in the UN Charter, you find this in the ASEAN Charter, you find this in the settlement of international disputes in international law. So it is really quite fitting that we have employed international law as a great equalizer, because it is on that plane that China, with all of its size, economic and military, is on equal footing with the Philippines. Also, although, as I said, disabuse yourself of this imagery, because really all states are born equal under international law. So let's now turn our eyes very briefly to the law of the sea dispute settlement regime. And when I say briefly, because we don't have much time to expand on this. So dispute settlement in international law operates on the basis of consent, and this is where China always try to confuse or confound audiences who are not well versed in international law by a very crafty play of words. So of course, consent is the basis of all jurisdictions. So if you cannot bring a state to adjudication without its consent. But this is where the Law of the Sea Convention is different from other conventions, and in fact, it's one of the defining features of the convention. They negotiated over a span of 3 decades, and in fact, even 2 conventions before that. This package deal of the convention included consent or built-in consent within the convention, which means if you sign or agree or become a party or accede to the UN Convention on Law of the Sea, you also agree to be part of a compulsory dispute settlement regime or system, which is in part of the convention. So normally, of course, if you initiate arbitration, interstate arbitration, or any claim within or before other tribunals, you would have a compromise or an agreement, a special agreement with the opposing state. But with the Law of the Sea Convention, it's actually built in. So any question of interpretation or application of the convention can be brought directly by the parties to the convention. And this is actually what the Philippines did. So the Law of the Sea Convention includes consent in its text. It's clear from the provisions of the convention. You look at 73, 74, 83, 186, 191, 226, 264, 265, and so on. Even the annexes, there are provisions which clearly indicates the consent. If you look at Article 309, it also says there's no reservation or exceptions. And this is really a defining feature of the convention. Other important features, articles, just to keep it flat. Article 279, parties have the obligation to settle the dispute by peaceful means, incorporating by reference Article 2, Paragraph 3 of the UN Charter, which imposes the obligations upon member states to settle the disputes peacefully. It also mentions Article 33, Paragraph 1, which means that they have to resort to peaceful means of their own choice to settle their disputes. Article 280 or 280 of the UN Convention on Law of the Sea is on the peaceful settlement of disputes. 281 lists on the procedure. So if you are a party to the convention, you have the choice of procedure in 287. When you sign, when you ratify or accede, or any time thereafter, you can choose freely which of the means through a declaration that you would want to use to settle your disputes. So it could be the ICJ, it could be the International Tribunal for the Law of the Sea, or UNCLOS. It could be an arbitral tribunal in accordance with Annex 7, which is what the Philippines did in the South China Sea Arbitral Award, or a special arbitral award, or a special arbitral tribunal for the categories of disputes specified in Part 15. So just a brief overview. I know that the Filipinos are, or not sure I cannot see the list now, a lot of you would be familiar with the literature, academic and otherwise. So the South China Sea is important because and contentious because of at least two reasons. The first is because of its geostrategic significance. It's a major sea lane of communication. Half the world's annual merchant fleet tonnage passes through the Straits of Malacca and so on. It's also important for its resources. It's the subject of competing claims by countries. There are groups of 4 archipelagos. The countries which compete is China, Taiwan, Vietnam, Malaysia, Brunei, the Philippines. I think I need to hurry because I'm running out of time. All 28 states have established military garrisons in the area. It's complex because of international law, geopolitics. There are also considerations of international relations. All states base their claims on international law, particularly UNCLOS. And as I said, UNCLOS doesn't have any provision on how to determine sovereignty over offshore islands. So this is just an illustration of the South China Sea in terms of the maritime zones and legislation of the littoral states. So it's really a tale of complexity because if you overlay the claims, the zones that the littoral states claim, as well as the zones generated by the geologic features themselves, you can see all of these complex lines. So you have the baselines from the coast, the baselines from the islands themselves. On the same map, you can see some memorandum of agreement with some of the countries. You can see unilateral claims from the Philippines, Malaysia, Brunei. There are also claims by Singapore. You can see the JMSU also in the same map. So it's very complex because of all of these disputes and lines. This is just a slide which shows you the features occupied by the various countries. So China occupies 8 or 7 there. I think it's from an earlier source. Taiwan occupies into Ava. The Philippines occupies 9. Vietnam occupies the most with 21, and Malaysia occupies 5. So some of these are within the West Philippine Sea or KIG claim. Some of them are outside of it. But clearly, the parties occupy features with the various degrees of facilities in those. So where are we now? So we have the arbitral award, which I will go very, very shortly through, and then the Chinese reclamation activities. I normally spend a bit of time flashing the pictures, and now I'm sure a lot of you will be aware of them, and they're all over, probably available on the internet. So just look it up yourself. But suffice it to say that the Chinese reclamation activities have done irreparable damage, as I said, noted by the arbitral award. They've changed the geography and landscape of the South China Sea, and these are things which took nature millions of years to build, and only for China to destroy in 1 or 2 years, and we would live with the consequences for years to come. Comparison with other countries, so China really has engaged in unprecedented and ecologically devastating dredging and island building on all the features that they occupy, and in stark contrast with other countries. So it has created more acres of land compared to the other countries combined. So it's not really the idea of China catching up. It's really dominating the reclamation for the South China Sea. So some procedural point. The Philippines submitted notification in 2013 to initiate the arbitral proceedings, and quickly in the month that followed, January 19, 2013, Chinese diplomatic note rejected and returned the notification from the Philippines. It made it clear that it will not participate in the award in the proceedings. The Chinese position paper on 7 December 2014 made it clear that they are against the jurisdiction of the tribunal. Some procedural points. So the Philippines submitted a written supplemental submission in 2015. The hearing on jurisdiction and admissibility commenced in July of 2015. The just like normal proceedings or arbitration litigation, the proceeding was bifurcated. So there was the first part is the jurisdiction and admissibility, which the tribunal dismissed, rendered its award in 2015, October 27. And then in 2016, July 12, the arbitral award, the arbitral tribunal released its final award on the merits. That's basically the award that we speak of when we talk about the South China Sea Arbitral Award. So what did the Philippines ask from the tribunal? So the Philippines seeks an award that declares the rights and obligations of the parties should be governed by the UN Convention on the Law of the Sea, and to declare the Chinese claims based on the land-dash line are inconsistent with the convention and therefore invalid. Article 121 of UNCLOS are islands, low-tide elevations, or submerged banks. And so the Philippines is asking whether these features are islands, are they low-tide elevations or submerged banks, which means are they capable of generating territorial sea or more extended maritime zones? And we'll find out, or you would have found out, that no feature in the South China Sea are capable of generating extended maritime zones. They're all only entitled to a territorial sea. That the rights should be governed by the convention. The Philippines, it was clear that the Philippines was not seeking any relief or judgment in respect of sovereignty. It was not also requesting a delimitation. So sometimes, of course, it's a very basic point, but some people still argue that the Philippines was seeking more than what it was seeking because of a technicality that they would like to point out, but it's not true. The Philippines was very mindful of the Declaration of China. It has not sought or asked for what is beyond the convention or the arbitral tribunal could award. So there was no question of sovereignty. It was clear from the pleadings. It was clear from the hearings. It was clear from the get-go and clear all throughout. It was not a question of who owns the features. That's a matter which would be settled elsewhere and not with the award. These are the reliefs that the Philippines sought. I think 13 of them, and on all counts, you can find this in the notification as well as in the arbitral award itself. We won on almost all of them. So again, just a recap of the 500-page award. Of course, mentioned a lot of things, and if you forget anything, just remember that the tribunal declared the China's 9-line claim, as well as China's historic rights over the living and non-living resources in the South China Sea, finds no basis in international law and incompatible with UNCLOS. So this is very important. This is the massive victory that we should not forget, and we should be remembering the award for, because as I said, and I know this through my interaction with scholars and government officials from within the region and even beyond, Chinese officials particularly mentioned this a lot of times in times past. So now you no longer have to honor that line, and you can be categorical in saying that once and for all, definitively, categorically, the 9-line claim of China is incompatible with the UN Convention on the Sea and has no basis under international law. Where do you find that? The arbitral award, of course. That's one of the massive victories that the Philippines secured. Secondly, that the Arbitral Award also declared that the reclamation activities of the Philippines, of China rather, interfered with the rights of the Philippines, and it caused massive irreparable damage in the environment of the South China Sea, and there are clear violation of Chinese obligations under UNCLOS. I've also written some papers on this on the duty of China in respect of the marine environment, Part 11 of UNCLOS, and the tribunal made clear that China violated its obligations under the UN Convention or Law of the Sea. Very important, none of the features are islands. So we kindly recall Article 1213 defines what are Article 121 rather defines what are islands, what are rocks. The significance is this, that since the features are merely rocks, for purposes of Article 121 paragraph 3, they do not generate entitlements to an EEZ or continental shelf. What does this mean practically? Practically, it means that the award has significantly reduced the degree of complexity, because now you only have to think of the zones to be generated as territorial sea and not EEZ or continental shelf, which means if these features are even for features which are within what nautical miles of the Philippines, they have to be enclaved, and the sovereign rights of the Philippines over the Philippines has over the subsoil and seabed pertain to the continental shelf of the Philippines, and therefore they are not subject to dispute. Hopefully you're able to catch that. So it limited the complexity of the dispute, and in fact it clarifies that some of these waters are actually undisputed or uncontested because they are not maritime zones that could be generated from these features, because they are not islands but mere rocks. It's an overwhelming victory. You won in every major respect. It's devastating for China. It was quite toxic during the early days that the Arbitral Award was released. And in fact, I recall a lot of things, my interaction with the scholars at that time, not so pleasant, some of them. But you can understand how China felt, because it was so devastating for them. It was really, the victory was so massive and overwhelming that you can almost imagine the reaction from China. It was difficult for them because it was difficult to have some wiggle room to save face out of the situation. Typical reaction from China: it's null and void, not binding. It will not recognize or accept the award. So it's important when we look at this award to make it clear to ourselves and clarify that whilst we recognize and we rejoice over the points that I mentioned earlier, there are still some questions which are left unanswered. The first one, of course, as I've emphasized from the beginning, is the question of sovereignty. So who owns the features? We don't know that. These are the tough questions we need to ask. So what happens to the artificial islands and reclamation work by China? Do they have to be dismantled? What about their liability for marine environmental damage? What about China's liability for or obligation for reparation? Are they a navigation hazard as such? Another important point is how does the Philippines proceed from this legal victory? So should it be part of the negotiating strategy for the Philippines when they negotiate in diplomatic circles for other things, one of which is the code of conduct for the South China Sea? Again, another point is the binding nature of the award on other claimant states. We know for a fact international that is only binding between the parties of the dispute, but you might, out of curiosity, consider the possibility of other claimant states filing similar cases against China. In fact, we know for a fact that other states in the region have been ready and are still ready, and they might do so. However, of course, we know the reaction from China that will not, be welcome. And again, there has to be a proper cost-benefit analysis and whether that should be done. Some positive aspects of the award: so the rules have become clearer. There's better basis for negotiation. Now we know what are behavior which are inconsistent with the legal order, and they should be called out for doing that. The agreement, the arbitral award made it clear that there are things which are uncontested, so it made the implementation resolution easier in a way. I flagged there positive implementation requires a cost-benefit ratio analysis. And then we have the point of the regional hegemon providing good implementation examples. So some scholars have pointed out to the Greek game happening within our backyard, the proxy game.
Yes, I'm sorry to interrupt, Dr. Bautista. just in the interest of time, we have gone a bit over the.
That's true. Sorry. I mean the last two slides, I think. I mean the last.
So if you could please bring us to the conclusion.
Okay. Thanks, Alex. So I'm so sorry. I didn't have the clock. Okay, so practical aspects. This is actually the most important part of the presentation. I should have spent less time in the background. But how do we enforce the award? So law enforcement activities. So when you speak of law enforcement activities, remember I just want to bring it to a solid close. Because remember I told you, ideas are powerful. Have we won in the award? And the answer to that is yes. Have we implemented the award? It's more nuanced, but I submit that it's been implemented. So these are the pockets of practical aspects where the award could be enforced or implemented. So the first one I flagged is law enforcement activities. What do I mean by this? I mean, you can enforce the award in terms of fisheries, which means you have to ensure and provide conditions to allow the Filipino fishermen to fish within uncontested Philippine waters. You can talk about MSR. This is now a raging issue because of some issue with some boys that they found in the WPS. You can talk about patrol and surveillance. You can talk about enforcement of Philippine fisheries laws, boarding, inspection, and aggressive illegal fishing. So law enforcement is very, very crucial. Traditional fishing rights access, very crucial. Paragraph 805 of the Arbitral Award says that traditional fishing rights are available in Scarborough Shoal for Vietnamese, Filipino, Chinese, even Taiwanese, and Chinese fisher folks in Scarborough. We can have access to agreements with these countries. It has to be by agreement. Philippine oil concession block, very controversial. I know for a fact that DOE has some blocks which are open for oil exploration. I want to say that there are some concession blocks which were not disputed. I know for a fact that Reed Bank, the government has made strong representations in terms of Reed Bank, which is about 85 kilometers from Palawan, for almost 500 nautical miles from Hainan. So some of these things could be explored unilaterally. I dare say some are being for joint development. We can do that. Finally, provisions of a practical nature without prejudice to a final delimitation. Again, the usual no prejudice clauses should apply, and they could apply to hydrocarbon, to fisheries, to a provisional boundaries, to an agreement for mutual restraint, conflict management, or moratorium. So these are very important practical ways to enforce the award. The award carries very heavy presidential weight. It should be the starting point of all of our negotiations. The Philippines should continue to use diplomatic and peaceful means to settle its disputes. The parties should have self-restraint and should not use force. Again, very important. The state should adhere and pursue a rules-based approach based on international law, especially the UN Convention on the Law of the Sea. Again, just some images to round up my point. I'm so sorry. Hopefully, you were able to learn something, and feel free to ask, and I'm happy to also address questions. Alex, back to you. Time flies. I don't know if we're having fun, but it did fly.
Thank you, Dr. Bautista, for that presentation. It's a wonderful reminder for, it's been 5 years since that historic award was delivered, and perhaps some of us have forgotten what it signifies for the Philippines to have to be in the position that it is said to have won something in an international arbitration. So perhaps what I would do now is to open the floor for questions if there are any. Perhaps I would take 3. There is one on the chat. Does May want to show herself, or should I just read her question?
So May is asking, how has China's behavior changed after the arbitral judgment? They said they do not recognize, but are there any changes to how they acted in the South China Sea? I don't think so. So one thing you can, if you look at Chinese behavior, it's very consistent. And as I said, it's not surprising. I'm not surprised with China's position. It's not binding. It's not It's null and void. What surprises me is when we hear it's a scrap of paper. I shouldn't remind you who we heard this recently. So those are the self-inflicted wounds by our Philippine officials, which shouldn't happen in public discourse. I also know for a fact, mind you, that there are also private, not public correspondences from the DFA, which also are positive. But on the Chinese side, I don't think so. I think their behavior publicly is quite consistent. They will never honor the award. They consider it null and void. In fact, they have cast aspersions of corruption against members of the Philippine team and the experts we have engaged. Those are not surprising. Recently, Senator Francis Tolentino filed a bill in the Senate to further define the baselines of the Philippines by drawing baselines around the rocks and other maritime features in the West Philippine Sea or South China Sea. There are similar moves in the House of Representatives. Assuming this is passed into law, what would be its practical effect on the dispute in the West Philippine Sea or South China Sea? This is very, very crucial, very timely. So I want to answer this straight to the point. Do we need to file do we need to pass a law defining the Philippine basins, especially on the South China Sea? I think the answer to that is a clear no. So we don't need to pass a law because we already have a baselines law, RA 9522. Further back, you have 3046, 5046. So they all define the Philippine baselines. Some of these discussions spring from the attack that the tribunal award has been getting over the Kalayaan Island Group claim, which some scholars are arguing that has nullified PD 1596. So let me just explain very quickly. Laws are not the basis for title to territory. I mean, the Philippines will have its day in a court where it will prove title to our claims in the South China Sea. The mere passage of laws would not be the decisive factor for that. What will be important is acts of administration, acts of sovereignty, which means the border patrols, which sometimes are prevented, all the declarations and so on. I mean, keep in mind, the passage of laws is a domestic concern. And corollary to that, right, is also the option, the sovereign prerogative not to pass the laws, not to name these features, not to include them in any way. So these are all sovereign prerogatives. So we already have a baselines law, and claims are not, the Philippine claim to the Kalayaan Island is not based on a law, but through acts of administration, effectivity. And these are the ones which will, solidify and strengthen our claims. How are our ASEAN neighbors treated or made use of the arbitral ruling? I was wondering about the geopolitical implications of the ruling, if any. Very, very good question. Because if you look at the bigger picture, who does not honor the award? China. Again, natural. That's natural. But look at the other side. You have the Philippines, us. You have all the major naval powers. You have USA. You have Australia. Okay, naval power. We have India, the UK, France. So within the period of 2011 to 2016, there's what the scholars call the battle of diplomatic notes. So even you can be assured, all the claimant states other than China respect the award. Of course, why not, right? And then all the major naval powers, we are in good company. And other than that, as I said to you, the power and forcefulness of international law. We don't necessarily have to rely on our government to do this because we don't have the economy or the military might to do this, but trust the process because international law has a force unto itself, which underscores compliance and enforcement without need of a body. So the ASEAN states might be divided because of checkbook diplomacy, but you can be assured they agree with the award, and of course all the major powers. Recently, after the award had its 5-year anniversary, the same thing, diplomatic notes from major naval powers. So we are in very, very good company. On the other side, China, of course, would have very little states to agree with its position. And of course, it's also natural because states only are very self-interested in nature. So why would they disagree unless they have interest in the dispute as well? Does the award?
Michael,
Alex, sorry.
freedom of, does the award significance if the Philippines explores joint development with China? Could the Philippines be stopped in asserting aspects of the award if it does this?
So does the award lose its significance? Joint development. To be honest, as I intimated in my earlier in my presentation, I'm very worried of joint development only because I've been looking at this issue for a long time. And mind you, some of the areas which are in dispute now were never in dispute. So when I mentioned read ban, some of these, I'm not saying that they're contiguous to us because contiguity has long been abandoned as a basis for claiming sovereignty. But some of these areas are really clearly within our EZ. And even if you, put the maritime zones range from the islands that they're occupied by, the rocks occupied with other Cayman states, they do not impinge on our EZ regime. So joint development for areas which are really, this is difficult. So, but my lawyer hat I could put on, of course, because the mention of estoppel here. So I'm sure that the person who asked might be a lawyer. Of course, the usual caveat should apply. So without prejudice, and you can have it ironclad that it's not affecting, and you can look at Article 73 and 84 of UNCLOS, provisional arrangements of a practical nature in paragraph 3 of those articles also allow you, those recourses. But I'll be very, very cautious to do this. And again, there's no monetary value to me. The Philippine polity in my imagination is without it's beyond calculation in terms of, it is of such importance that no amount of economic returns could justify us giving what is rightfully ours. That's my personal position.
The next question is from Dita Lilianza from the Center for International Law at the National University of Singapore. How do you see the role of the ASEAN in the dispute? Perhaps a similar question comes. The next question also touches upon this from Ms. May Iban. Has ASEAN helped the Philippine cause at all through DOC or COC process? How important for the Philippines to continue to engage through ASEAN?
The ASEAN is built on principles of non-intervention. So the way ASEAN is structured will not lend itself to the resolution of the dispute. It's more for dispute management. In 2017, after we won the award, we lost the opportunity because we were then chair of ASEAN, and succeeding chairs also, country chairs also did the same. Why? Because of course China, I would say, all of this is a recorded public forum. Money talks, checkbook diplomacy. It's very difficult to fault countries for siding with China because they also benefit from China. The same way that, through a judicious cost-benefit analysis, maybe the Philippines has done the same. That's why we realigned our foreign policy after the arbitral award victory. Can we rely on ASEAN? I don't know what you mean by relying, but definitely, what was I mentioning? Oh, the DOC-COC process. This must be one of the longest code of conduct negotiated in the whole world. After 20 years, tumanda na ako sa DOC, COC, wala pa rin tayong COC. So we have a declaration, we have no code of conduct. Because if you're wondering whose behavior, I'm very provocative always, whose behavior we're actually regulating, guess which country? There's only one country which the code of conduct seeks to regulate, and behavior seeks to regulate, and that's China. So unless China, look at the declaration, look at the code of conduct, look at the actions which should not be done there. No provocative actions, no new occupation. We've done what we have to, but unfortunately, China cannot be relied upon. So really, there's a trust deficit. I'm saying this, not as a Filipino but even as a disengaged, scholar from all of this. You can look at the behavior of China, and really you can understand the trust deficit. We sit at the negotiating table, the Philippines sits at the negotiating table, they agree on some points, and then look at China's behavior, and look at the double speak as well, look at the language, look at the behavior. So that's why, another thing that is missing, I think it's a white paper as well on the South China Sea for the Philippine part, because you see a lack of coherence. As I said to you guys, I've been working on this for over 2 decades. There's really no coherence, no continuity, no grand plan or design no, not even a proper study of our pronouncements. And mind you, China does this on a daily basis. They check all our statements, all our declarations, all our policies, all statements, and they catalog that. Why? Because who knows, in future there will be litigation. They would say this on X date, your president said this. These are the effects on your claim. So we have to be, we have to be more prudent. We have to be more forward looking, and hopefully that's taken positively by the government. Alex, do I still have time? I'm happy to stay on. Sorry.
Perhaps what I would do is to take up my moderator's prerogative, because there had been a lot of questions before I was able to you usually ask the first question. So you mentioned in your presentation sovereign equality, like formally, at least in international law, there's a notion that states are equal when they are in the eyes of international law. And so perhaps what I wanted to ask is, how do you take account of of power differentials in the question of enforcement in international law? Or perhaps another way of asking this question is, should international lawyers be interested, or should they cleave to the question of power differentials in international law more broadly?
Okay, I'm not familiar with the intellectual architecture that upon those questions are premised, Alex, I must confess. So how can I answer that? Of course, there are differences in power. I'm reading a book actually at the moment by Professor Antia Sherlow about international law, so which reminds me. Anyway, what's your question again, Alex? I got lost in my own thoughts. Sorry.
Yeah. How do you take account of power in the question of enforcement in international law? I mean, we could probably keep on mentioning that yes, we are formally sovereign equals in relation to each other in this field called international law. But on the other hand, we can't also close our eyes to the fact, to the reality out there that there's really simply great differentials in power between certain states. And these are things that we cannot ignore. And how do we take account of these differentials in power in the question of enforcement in international law?
I think your question also answers the question itself, because as you said, we cannot ignore. So these are realities we have to contend with. And power, in my view, as I said, I don't have the the intellectual architecture to understand the question in its fullness. But power for me is multifaceted. Of course, by all measures, economic, military, and so on. There's disparity between China and the Philippines. But when you look at the international law, that differentiation is actually ignored. I don't know if you necessarily agree with that proposition, but it is, I agree, a great equalizer, because otherwise the whole architecture crumbles, because that's the cornerstone of the Westphalian model of state relations, that every state is equal and sovereign. So setting aside differences in power and in military and economics, I think the Philippines relies only on international, on its own force. I don't know if it's also I mean in the sense, in the positive sense, it carries its own force and power. But if you look at the practical, I remember some Tyrosen's differentiation in international litigation. There are two phases. The first one is the adjudication phase, which is the Southern Arbitral Tribunal, which is governed by law. And then the other phase, the second phase, which is very important, post-adjudication, which is governed by politics. So this is where we are now. That's why, the lawyers are important in the first phase. The second phase is more for diplomacy, for policy experts, for issues of military and naval issues and so on. So this is where we find ourselves. So if you look at the strategy of the past administration, they were not just relying on law. They were relying on the goodwill of other countries, the weight of public opinion, the censorship that might have followed to compel China to comply. So these are all, I mean, related to power, but also extraneous to international. This is becoming more theoretical than what I intended, but hopefully that as a response to your question, Alex.
Thank you. That's wonderful. We have I think it's a comment from Nina Araneta Alana. Perhaps for the Philippines, coalition building with traditional allies and geographical neighbors can be a counter to that power differential with China. So a sort of hedging in our international relations, which seems to be what's happening with at least what the president is doing right now in terms of his relationship with the U.S. and China. Do you have any insight in that matter?
Which one, Alex?
I mean, the way that the president sort of conducts his foreign relations with the United States and China, sort of hedging.
President Biden or our president?
President Duterte.
President Duterte, the outgoing president. So again, looking at the structure of, and I'm mindful, Judge Raul Pangalangan is in the cases I see on my screen. It is a prerogative of the executive. So the tenor, the cadence, the direction of Philippine foreign policy is upon the shoulders of the chief executive as the architect of Philippine foreign policy. So that's understandable. Again, there will be a point to where an accounting will have to happen, but and also in terms of its possible effects to the claim. But this is where the complexities happen, because you're looking at it from both the legal appreciation of the past as well as some political. I'm reminded of what Justice Carpy mentioned in stuff. There's I shouldn't mention. Anyway, he said that he can sum up in one word the main obstacle to the enforcement of the Philippine Arbitral Award, and he said Duterte. So I'm not saying that it is his position, but I mean, within the ambits of the office, those things are well, perfectly valid in an exercise of his prerogative.
Okay, so we have time for just a last round of questions. If anyone wants to raise questions at this point. Yeah, I think, yeah, I think that's all of the questions for this evening's presentation. Thank you, Dr. Lowell Bautista, for accepting our invitation to present with CERN Melbourne tonight. And thank you for all of the participants for joining us this evening. I hope you didn't have any trouble finding the link to the meeting tonight.
Alex, can I indulge because Judge Pangalangan is here? I couldn't resist. Wait, Judge, can you mention? Hi, Judge Pangalangan. Can you say a few words? Just to, since you're already here, sir. 1 or 2 words.
Well, thank you so much, Lowell. I'm sorry for coming in. I was a judge in the moot court competition, the final round in Nuremberg. It overlapped with your forum, so I'm able just to catch the end. I couldn't exit from the other one because I was presiding judge. Well, actually, Lowell, we really need forums like this because the topic is so technical, it's quite difficult. And also we have to, it goes back and forth between the debate internal to the law of the sea, which is international law. And then you go into the, as Alex was saying earlier, into the intricacies of Philippine constitutional law, reconciling the arbitral award with the decision of the court in Magallona versus Executive Secretary, and of course our own internal legislation. So we really need these forums, and I'm so glad, Lowell, that you organized this. How I wished I was able to hear the whole presentation. In fact, Lowell, if you have any writings on this, please send me. And I think the College of Law is, at UP is planning to organize a faculty forum. I hope you will speak there as well, Lowell. Thank you.
That's as always, you're so kind. Thank you for gracing this. And Alex, also alumnus from UP Law organizes actually. Thank you, Judge.
Yeah, in fact, I'm so I'm so happy to see that Alex is right in the thick of these forums. So good to see you guys.
Thank you, Judge Pangalangan. Of course, Judge Pangalangan was my professor for constitutional law and supervised legal research when I did my law degree a few years ago. But thank you for attending tonight's event. If there aren't any further questions, I think we can conclude it there. Or if anyone's interested in taking a sort of a class photo, you could please turn on your cameras, only if you want to, and we can take a screenshot of the screen. Right. Okay, so I'm starting it now. And another one. Okay, another one. Right. Thank you for coming this evening. Thank you for joining us. This will be available later on at the CERN Melbourne YouTube account. And please join us again for another installment of the CERN Discussion Series. Thank you and mabuhay.
Okay, bye-bye.